We have about 24 questions right now, and I'm just going to go right into the question and answer part of our class today. Okay, our first question is it good practice to request a copy of the property management firm's cyber liability and data breach policies? Is it important to show our HOA as an additional insured? Great questions. So yes, I think usually the cyber liability and the data breach policy is, packaged in with the policies, but you want to ask, can I please see a copy of your declaration sheet for the association's management company? If you can have the association listed as an additional insured, I would recommend that as well. Okay, next question. Are there any legal requirements for an HOA board that they must take for use of part or all of the reserve funds? Example, a vote of all owners to approve the expenditure. I mean, it really depends on what your association documents say. Sometimes documents will say anytime the board's going to spend more than 50 grand or 5 grand or 100 grand, they have to get a vote of the membership. So, that's kind of unusual. I would say maybe like 15% of associations have a provision like that in their documents. Otherwise, if you don't have a provision like that, the board can just vote at a regular open board meeting to, move forward using reserve funds, to handle certain reserve items. Okay, question 3. Can an HOA completely ban homeowners from renting their homes in its community? So we have a great cheat sheet on this topic called Amending CC&Rs and Implementing Rental Restrictions. Your question is kind of a loaded question because I don't know what your association's documents say about rentals. It is difficult in light of a recent case that was decided in Arizona for an association that may not have had any restrictions on rentals previously to implement restrictions such as you can't rent anymore on existing owners, based upon this particular case. So what I would say is, can it be done? I have seen it done previously, but I think that we need to look at this new case that was decided a couple of years ago, look at your association's documents. You may be one of those associations where you no longer have the right to do that because it would be something that wasn't foreseeable. And, in those cases, what we may want to do is just implement that so it's only for new owners who are moving in to the association after that amendment is recorded. So there's ways to do it, but it's kind of a complicated question without seeing all of your association's documents. Okay, question number 4. Our community members have requested a special meeting. The board president decided to use the same date as the regular meeting and plans to use her agenda, bringing in a speaker. We've requested it to be a membership meeting, not a board. What can we do? Well, a couple things. Okay, so if you requested to have a special meeting of the membership, technically the board is still running the meeting. If you wanted to have a separate meeting that wasn't a special meeting of the membership, which you are entitled to do under Arizona law and use the association common areas, it's not classified as a special meeting of the membership where the association is sending out, notice to the membership, not less than 10 days in advance of the meeting, etc. So there's kind of a difference in that. One's a formal approach and one's an informal approach. If you are doing it the formal approach way, the board has control of that meeting and they can, yes, owners will be allowed to talk during that meeting, but the board is going to be setting that agenda unless when you gave the notice request that, there was a specific agenda that you wanted to have addressed, then they would have to add that to whatever they wanted to address. If it's an informal meeting, you're more in control of everything and you're allowed to have it on the common areas. So hopefully that helps to answer your question. Question number 5. During a recent discussion of a petition for a variance from the architectural guidelines in the executive session, a board member stated that people should do what they want as long as it doesn't hurt anyone. What are some of the issues for the association as a business with this approach? Well, I think as a board member, you're required to uphold the association's documents. So if your documents say you can't do something, you should not be allowing that. if you want to change that, you should be amending the documents to change it. So I think we have to be really careful as board members when we make a statement like that, we might be potentially breaching our fiduciary duty to the corporation if we're not following state law or not following the association's guidelines or CC&Rs or other documents. Okay, question number 6. We would also like to ask your view on House Bill 2442, which is currently pending in the Arizona legislature. With the language in the bill, or will the language in the bill prevent an association from using reserve funds allocated to specific assets in the study for other purposes? For example, if our reserve study provides for $2,100 for replacement of electrical panels in 2025, would we be restricted from using those funds instead for something different? Okay, so House Bill 2442 is, still on the House floor. It is in a special COW action as of 3/12. Honestly, this one's not moving that fast. So, any bill that's likely to have a chance to pass this year, it really would need to be passed in either the House or the Senate already by now. And so it's still undergoing amendments. So I'm kind of thinking this one is probably not going to take off, but some of the things, and these bills, the language changes from day to day. So, as of right now, my information is that it would prohibit associations from passing a special assessment or obtaining a loan for extraordinary or unanticipated expenses and using a regular assessment or a loan for unanticipated expenses. Any proposed budget, including critical expenses that have risen more than the CPI, would require ratification by the owners and amendment of the budget to meet the owners' changing priorities under the penalty of removal. So, there are some different budget parts to this bill that, are making it more difficult for associations to do things without a vote of the majority of the members. It's not a good bill in my opinion. So I don't think it's going anywhere this year, but we'll have to wait and see. Okay, question number 7. We have submitted a petition to recall our HOA president. Our documents do not require cause, but we think it's best to let homeowners know why. We aren't lawyers, so we plan to write up facts about performance, any advice. So I would recommend that you look at our top 10 cheat sheet, and number 6 on that top 10 cheat sheet. We're going to be sharing that with you here. You can find it on our website at mulcahylawfirm.com. It outlines the procedure for removal of a director from office. Okay, so what are some suggestions if you're planning on, putting information out there about why you think the president should be removed? Be really careful what you say, because if you say anything that is false, you potentially have, a defamation claim against you by the president. So stick to the facts. That's probably the most important thing that I can tell you, and make sure whatever you're saying is true. Okay, and honestly, just to back it up even further, please try to reach out to the board to discuss these issues before you go the route of a removal petition, because removals are very expensive for associations. You're looking at costing the association somewhere between $5,000 and $10,000, maybe even up to $20,000, depending on how contentious the removal petition is and legal fees. And that is money that you don't budget for. And it's just out the door. And it creates a lot of division in the communities. The realtors start to, get wind that, there's problems on this board and there's problems in this community. There's a recall meeting going. It's just not good. So it's really a last resort thing that I would recommend. Try to talk with key people on your board to resolve the issues if you can. Okay, question number 8. I've heard you say in one of your talks from a while back that you recommend having the treasurer of the association write the HOA checks rather than the management company. Would you please share the reasons for this view? Okay, yes, I've already talked about this during today's presentation. I think over a certain dollar amount, I think that the checks of the association should be signed by at least one board member, if you can, 2. My association, every check that's written for the association is signed by 2 directors. Why? Because we're looking at the backup material. We're making sure that this, bill is for our community. We're making sure we're paying the right amount. No one is going to care about the money of the association more than the board members, because they're also members of the community, and we know how little money we have. And so it takes away that opportunity leg in the triangle. If we are now the only people that can sign checks. Okay, next question, number 9. We currently pay our assessments quarterly. Some homeowners have requested to pay monthly. How can we allow them to be monthly without them incurring late charges? Really, there's no way around it. If your documents call for quarterly payments and they choose to pay, a payment plan, over those 3 months, they will incur a late fee at the end of the first month or whatever, the 15th of the first month, because they haven't paid in full. Okay, number 10, what does a healthy relationship between a title company and an HOA board consist of? Well, a title company, really, we only see their involvement when there's a sale of the property in the association. And so, it should be very businesslike. There shouldn't be any issues. I can't really think of any time that there have been issues between the board and the title company. Title companies are very professional. They basically are just handling the sale of a property. So there really shouldn't be any issues. I guess the only thing I can think of is maybe if the title company is refusing to make an owner or a buyer pay for some debt that's owed to the association, you may want to get the association's attorney involved to help navigate that. But for the most part, everything should be arm's length, professional, business-like. Okay, question number 11. We are having our annual meeting this week. I thought this was the meeting where the members of the community could state their concerns at the microphone and get answers from the board. I was told that this is a members meeting and the board just listens. What meeting allows the board to answer concerns? Really, the board, it's kind of a fine balance between the board being able to get their business done at, regular meetings, regular meetings that are monthly, and annual meetings and special meetings of the membership, and making sure that the owners feel heard and responded to. So here's what I, recommend. What meeting allows it? I hope that your board is being responsive and answering questions, but they can't let those questions hijack the entire meeting. So there's a balance. So, the board isn't required to answer every single question that comes up at every single meeting. If there's a large number of people that have a large number of questions, the board needs to know that, hey, there's some problems here in the information chain because people aren't understanding or they're not getting the information. Maybe you want to have a special town hall meeting where all the board does is answer questions of the owners. So, to a certain degree, the board is, doing short answers to questions that may come up at a board meeting or short answers to questions that may come up at an annual meeting. If you need more of a deep dive, the board needs to be thinking about why are these people wanting so much more information? They should be getting it from the minutes or from communications that we're sending out. Maybe the board isn't doing a good enough job communicating is what I'm thinking. And we need to have a town hall to clear up any things that people need answers on. Otherwise, this is going to go spiral into a removal meeting, which nobody wants. Okay, question number 12. I own a condo unit in a single-story building, 4 units to a building. I'm interested in putting up solar panels to help offset my usage on the section of the roof exclusively over my unit. I understand that Arizona has a law in the books preventing HOAs from outright disallowing solar panel installations. But how does that apply if a unit owner does not own the unit's roof? Does the HOA reserve the right to refuse a solar installation for a unit if the association owns and maintains a roof? Each unit has its own SRP meter. The association does not have any current or future plans for community-wide solar installation and does not have the funds to do so, even if they want. Okay, so we have a cheat sheet on solar panels, which I'm going to encourage you to take a look at. In a planned community, an association, cannot effectively, but you live in a condo and the roof probably, I'm guessing, is going to be maintained by the association and is not part of the legal description of your unit. And so, sometimes in those situations where there's, a roof and there's 4 units in your building, associations that are condos are not allowing it because it's their property, the association's property, and they void the roof warranty, etc. So I have seen it work in some condominium associations that it can be done, but more likely than not, they're probably going to say no. But, reach out to them, talk about your ideas. If you're paying for it, you may have to indemnify them if there's any problem with the roof. It's going to be more difficult to get them to do this, and they're not, required under that same law, to allow this because they own the property. Okay, question 13. Is additional insurance required to cover community EV charging stations installed by APS? What I would do on that is I would talk to your insurance agent and see what their position is on that. It's possible they may require additional insurance. It's also possible they may say you have plenty of coverage, don't worry about it. Okay, question 14. Our HOA is 40 years old. One amenity that was offered way back when a racquetball was a racquetball court, but it has not been used in years and is in serious disrepair. We're trying to figure out what to do with it, but the board thinks we cannot tear it down because it is listed as an amenity in our 40-year-old CC&Rs. Do you think it would be an option, expensive I'm sure, to remove it? I think that your board needs to reach out to their legal counsel and talk about this, because this is a change of use, likely because you're going to either remove it or maybe put in pickleball courts or something like that. And you likely will need to amend your CC&Rs to do that. But I think it can be done, but it's going to take a little bit of planning and likely a vote in the membership. Okay, question number 15. At our February meeting, a board member moved to increase the monthly HOA fees by $25, which was seconded and approved by a 3-2 vote. We are in process of removing 2 board members. Once those 2 board members are removed, can the remaining board members make second and vote on a motion to rescind the monthly HOA increase? So I have to see your documents in terms of, how they're set up and whether or not this increase was legal in the first place. But generally speaking, yes, once the new board is in control, they certainly would have the right to reverse this. But I would seek legal counsel before you do that, because I haven't seen your documents. Make sure that you're doing it properly. Okay, question 16. If the developer is still in control of the HOA, is the D&O insurance paid for by the residents covering the developer and property manager appropriate? If the developer is serving as a board member, and it sounds maybe like the property manager might be a board member too, based upon how you worded this, yes, typically the D&O insurance, if they're serving as board members, will be covered by the association's funds. The director or the developer will have their own insurance for their developer responsibilities. But for the responsibilities as a board member, yes, they will likely have D&O coverage for that. We have a great cheat sheet on transition from developer to homeowner control that I would encourage you to take a peek at, since you're right in that alley right now while your developer is still in control of your association. Okay, question 17. Are homeowners able to request copies of the association's insurance policy? Yes, absolutely. Just make a records request and the association is required to provide that to you. Question 18. Currently, trash cans, campers, and trailers on public roads are enforced per our CC&Rs. However, given 33-18-18 and the amendment in 2023, are HOAs whose declarations recorded after 2015 unable to continue enforcing what is in their documents? So we have a great blog on this topic, pertaining to the different laws that have been passed about planned communities, which have, streets that are dedicated to the public or dedicated to a city, town, county, municipality, and whether or not the association can continue enforcing what is in their documents. So if you're an association that falls into one of those categories that after 2025, your CC&Rs are recorded after that date, I believe it was 2015. I'd have to go back and check because I don't have the statute right in front of me, but 2015 appears to be correct. You would not be able to enforce on-street parking if the streets are dedicated to the public and your planned community. So, I'm not sure where you, are in this, and I'm not sure if your association, had CC&Rs that were recorded before this date or not, but, this is a complicated topic. Take a look at our blog on this. Question number 19. I bought a unit of a townhome within a community and found that the HOA didn't have insurance, and thus I could not get a loan. Can I sue the board of directors for not placing insurance? Okay, so it sounds like you're an owner in a community and you're unable to get a loan because there isn't insurance. I don't know if this is like a supplemental loan or like a HELOC or something. You know, and I don't know if the board really doesn't have insurance or they have minimum insurance or what's going on here. So it's kind of hard for me to, raise that issue. I mean, if they violated their CC&Rs and they're supposed to have that insurance, it's possible you may have a claim. Okay, next question. Number 20. If an event occurs with the HOA where they act in a way that brings a lawsuit, but the policy that was active during the time of the breach has just expired, does the new policy handle the claim or the old insurance that was active during the breach? It really just depends on how the policy is written. Some are claims-based, and some are, occurrence-based. So I'd have to see your documents to determine. As long as there's no gap in coverage, it should be covered by one or the other. Okay, question number 21. My CC&Rs require a 2/3 vote to change insurance to bare walls. What are my options if I don't get the 2/3 vote? Well, I don't know what your current insurance situation is, but I'm guessing that you're wanting to go to bare walls to make the policy, cost less. I mean, I guess you can play with the deductibles. That's certainly something that you can do. I'd have to see your CC&Rs to give you, more information about, what your options are. If I play with the deductibles, I mean, like have a higher deductible amount to lower the premium type thing. But you definitely need legal advice if you're in this situation right now. Okay, question number 22. How can I determine the rating of my or other insurance companies? Where is that information available? You should just be able to Google that pretty quickly. If you can't find it right away, you can contact the insurance company and ask them specifically what the rating is, or your insurance agent should be able to give that to you very quickly. Question number 23, looks like we're up to 29 questions now. In our long-range planning document, road maintenance every 2 years and possible reconstruction after 14 years is included. The board voted to increase annual dues within the amount allowed in the CC&Rs to avoid a special assessment to pay for road work and inflation in the monthly costs of the community. Should the funds collected for the road work be kept in a separate account from the inflation costs being incurred? We currently have the funds in one reserve account. Okay, so you increase your annual dues, and you want to have this money go into the road work account that you have for your association. I don't think it needs to be in a separate reserve account, unless you voted that it was going to be that way, but just you can keep track of it in the reserve account. And indicate, you can have like a subcategory in your financials stating that, there's a subcategory for the roads. I think would probably be the best way to do it. Check with your CPA. They may have some other ideas. Okay, question number 24. Do you anticipate in the future HOA community managers will be required to hold active Arizona real estate license as commercial property managers are required to hold? No, I don't. I think that there is very strong lobbying by the management companies to not be required to have any licensing in Arizona. And there are very rarely bills that are introduced like that. And when they are introduced, they're quickly shot down. So based upon my experience of watching the legislature for 30 years, I don't think that is in the future, in the near future for sure. Okay, question number 25. Our prior board, in place for approximately 5 years due to apathy, did not adequately manage the community nor the property management company. Monthly assessments were not increased, while massive insurance increases took effect. And a water leak was let go for months, accruing massive water bills. We have a new board in place and switched property management companies, but we want to recover some of those funds. What recourse does the new board have? If we go after the old board, do we risk the insurance claim? We'll raise our rates further at the renewal. So yes, this is a problem, because if you sue the former board, you're basically suing the association, because they will have insurance coverage under the D&O policy, and it'll be a claim on the association's insurance policy. So it's really not smart to do this because it'll ultimately end up increasing your premium, maybe even more than you might get from a claim like this. So, I mean, unless there is really like fraud or something like that, that wouldn't be covered by the insurance, or the amount is, so high that, this is our only option. We have to do it. Other than that, I would say, wouldn't normally advise you to do that. Just sue the former board members. Okay, question number 26. We are 7 associations and are self-managed. We currently do not have an agreement. Arizona statutes say that there should be an annual agreement with the self-managed property management company. Thoughts? So I am a little confused what your question is. So if you're self-managed, right, which means that the board manages the association. I'm not sure what you mean when you say we do not have an agreement, because the board should be managing it because you're self-managed, or maybe, I don't know, maybe you have like a property manager on site. I guess if you don't have a contract, what the implications on there are that they can, leave anytime, you can fire them at any time. It would be best to have an agreement in writing, documenting the employment relationship. But if you don't, many associations don't. If they have an individual manager that's, like working for the association, I'm not aware of anything that says that there has to be an annual agreement on that. So hope that answers your question. Okay, question 27. We have 4 questions to go. Can the board require homeowners to be insured for their private property? And if the governing documents permit fines, fine the owners for non-compliance. So in order to fine, there has to be a violation of the association's documents, the CC&Rs, bylaws, or rules. I mean, I've never seen an association fine for not having insurance. I suppose literally if it's in your documents that the homeowners are required to have this insurance and that the board, they're required to provide us a proof, I would say, and get the result that you want, you may have to sue them in order to get them to, carry the insurance. Okay, next question, number 28. Are management composites of dues or fees that they collect throughout each month to our operating account? As treasurer, can I request that they give me an itemized breakdown of what each deposit consists of, every individual amount and unit number that has contributed to the total of each batch deposit amount? I think that's a valid request. See what they say. And if they say, no, we can't do that, then say, well, what can you give me that will give me comfort so that I can better understand this deposit amount, what it is, how it is divided up. Okay, question number 29. What statements are needed in the HOA CC&Rs to best protect a large reserve fund balance? That's like that all board members, are listed on the reserve account, and that, a majority vote of the board is needed to remove any funds from the reserve account. I think would be all good things to put in place. You could also you put it in the CC&R so it would apply to every board, future board, going forward. The board could also adopt a policy if you don't want to do an amendment because it's too expensive or you don't think you can get the votes. That board could adopt a policy. Of course, future boards could unadopt that policy, but that might be another way to handle it without a vote of the membership. Okay, last 2 questions. If an association is successful in obtaining a loan against the HOA to replace or repair roofs that they are currently responsible for, can individual homeowners be held responsible should there be a default? Traditionally, no. Usually the collateral on HOA or condo loans is future assessments. The bank can take future assessments if they don't meet the obligations under the loan. Also, would a homeowner who puts their home up for sale, would they be required to disclose the amount of the loan? Does it show on a title report? I don't know if it shows on a title report. It would be a lien on the property. It's possible it might. And I think I would ask your realtor if you think that's something that needs to be disclosed or not. Okay, question number 31. I'm currently the only board member for our community. Is that a problem? I would say yes. You likely, I don't know, I haven't seen your documents, but I'm guessing maybe you have a small board, like 3. You really need to have more than one person to have a quorum. Unless your documents are set up where it's one person can make decisions for your entire community. That would be very, very rare. So my best advice to you would be reach out to your attorney, talk about this issue, look at the number of board members you're supposed to have, and maybe come up with a strategy with the attorney to try to get more board members. We have many learning opportunities in April. So we're finished with our questions, moving on to, what's going on in April here. We're, 3/4 of the way through March, but April is going to be a very busy learning month in our firm. And so just some future classes that we're going to be teaching in April. So we're going to have our virtual First Friday event, which we always have. We can ask questions and we answer them at no charge. And that First Friday class will be Friday, April 4th at 9 a.m. Then we have class number 4 of our 2025 virtual HOA Academy. That is going to be the 3rd Tuesday of the month, just like always, Tuesday, April 15th, tax day at 11 a.m. And we're going to be talking about vendor relations from hiring to firing. And we're going to be talking about management companies, landscaping companies, how to deal with problems, how to hire a vendor for a large capital improvement project. Vendors. We're going to be analyzing it and giving you the best advice possible so that you can have good relationships with your vendors. And if it's not working out, what are some ways that you can get out of it? We also are going to be teaching some classes for the city of Chandler by virtual classes. And we have a couple of virtual classes coming up in April. And it's called the City of Chandler HOA Academy Mini-Series. It's going to be on Wednesdays in April at 4:00 p.m. via Zoom. And it's going to be April 2nd, 9th, 16th, and 23rd. You can go to our website to find out what the topics are for that Chandler HOA Academy miniseries. I'm pretty sure that they're encouraging Chandler residents to attend, but anybody else who wants to attend certainly is welcome to attend. Last but not least, please, if you wouldn't mind, consider leaving our firm a Google review or a Yelp review. We're going to be sharing a link right now in the chat on how to leave a review. We are always happy to get feedback from our valued customers and attendees at these classes so that we can continue to improve the programming for the classes. And if you like the classes, it's really important that you let us know through these reviews, because we will pass those on to the different neighborhood services that are requesting us to teach these classes, because we're always at risk that maybe at some point, these different neighborhood services departments decide to go in a different direction and not have virtual classes anymore. And I think we can tell from the attendance here today that these classes are very valuable to a lot of people. And the best way for us to pass that along to them is to have you do a review on Google or Yelp. And like I said, we shared our review links with you, and we would genuinely appreciate it if you would do that for us. I hope everybody has a great rest of March. A lot of people on spring break, I know, and a lot of snowbirds in Arizona right now. Thank you so much for being with us here today, and we look forward to all of our teaching opportunities. Looks like we have about 6 in the month of April. Hope to see you at one of those events or more of the events. Take care, everybody. Have a good rest of March. Bye.